Hello, this is Irv Patton in Merrimack, New Hampshire. This special report will bring to light how the Medicare agency and its contractor, Anthem Insurance, are colluding to defraud doctors. Medicare and Anthem are willfully violating Section 1175 of the Social Security Act by refusing to transact electronic insurance claims directly with doctors. Instead, they are engaging in antitrust behavior by granting exclusive rights to certain private companies and then forcing doctors to hire those companies. The motive of Medicare and Anthem is to shift costs from themselves to doctors. Section 1176D of the Social Security Act grants authority to the state attorney generals to take action on behalf of residents adversely affected by violations of this law, including stopping further violations and obtaining damages. Therefore, we will show the facts of our case here and seek the help of the attorney generals in the states. If you are a doctor or a vendor who has been harmed by Medicare forcing you to pay third parties for electronic transactions with them, we encourage you to join our actions within your own state. In this brief report, we will present irrefutable evidence of the illegal behavior by Medicare and Anthem and explain the laws they are violating. This diagram shows how insurance claims flow in the healthcare system. A doctor treats a patient and then sends a bill to the patient's insurance company. The doctor has two ways to bill insurance: paper or electronic. For paper, he or she fills out a one-page form and mails it. For electronic, he or she transmits a standard format text file directly to the insurance company. The electronic method is regulated by Title 11C of the Social Security Act, which was added in 1996 as part of the HIPAA laws. Section 1173 of that law set standard formats for insurance claims, and Section 1175 mandated that insurance plans, including Medicare, must transact standard claims directly with doctors. In 2003, with support from this law, I started transacting standard format claims with insurance companies for doctors in the New England area. I wrote the software, set up the computer hardware, and made the necessary agreements and connections with the insurance companies. I was contracted by each of the doctors and was covered under Title 11C of the Social Security Act. By 2010, I was submitting about 20,000 electronic claims per month for doctors in New England to all major insurance companies, including about 10,000 claims per month to Medicare. In 2008, Medicare awarded the contract to process Medicare claims for Connecticut to National Government Services, known as NGS, which is a wholly owned subsidiary of the Anthem Insurance Company. In 2010, NGS announced that it was instituting a new policy and it would no longer transact electronic Medicare claims directly with doctors. Instead, doctors would have to purchase services from one of 6 private companies who were now the only ones who would be allowed to transact directly with Medicare. NGS coined the term network service vendors to describe these new types of businesses. This postcard advertisement from one of NGS's so-called network service vendors was actually sent to me at the very time that NGS announced it was cutting off my direct connection for transacting electronic Medicare claims. NGS implemented the same policy for all the New England states when it was awarded additional Medicare contracts in 2012. This diagram shows how claims flow between doctors in New England and Medicare after the NGS changes. There are 3 players: the provider, the plan, and the so-called network service vendors who the doctors must hire to get their claims to Medicare. The doctors must enter into 2 separate contracts with the so-called network service vendors and pay a monthly fee to them. The contracts include a formal business contract and a government-mandated business associate agreement. Neither of these contracts would be needed if Medicare transacted claims directly with the doctors as required by Section 1175 of the Social Security Act. Here is an excerpt from an actual contract with the private company name blacked out. The highlighted text shows that the doctor will have an account on the private company's computer, which will be used to get claims to Medicare. This proves that it is not a direct transaction with Medicare and does not meet the requirements of Section 1175 of the Social Security Act. Also, the apparent collaboration of Medicare in the drafting of this contract, in conjunction with Medicare forcing doctors into this fee-based contract, proves antitrust behavior. Medicare has no right to force doctors into either of these costly and burdensome contracts with these pseudo-governmental private entities which were illegally created by Medicare and its contractors. I filed formal complaints with Medicare and NGS on this issue. I received one response letter from Medicare and two from NGS. All three letters denied wrongdoing and misrepresented the truth. Medicare stated that their contractor was simply outsourcing connectivity, which was completely false. One of the letters from NGS was sent to U.S. Senator Jeanne Shaheen from New Hampshire, who had looked into the matter when I asked for help. That letter, shown here, might best be described as mumbo-jumbo and was clearly designed to mislead the senator. This diagram uses formal legal terminology from the HIPAA laws to show how claims are supposed to flow in the healthcare system. It shows the provider, the plan, and their contractors. The provider transacts a claim with the plan. The claim starts out on the provider's storage media, travels via transmission media, and ends up on the plan's storage media. The diagram shows that the provider and the plan may each outsource work to their own respective contractors. Providers and plans routinely outsource various tasks, and outsourcing computer work is common. Whoever outsources a task will hire someone to do it and enter into the needed agreements. However, Medicare and NGS say they are outsourcing to the so-called network service vendors, but in fact are forcing doctors to hire those vendors. This clearly is not outsourcing, but is antitrust behavior. We now cite the statutes and regulations from the HIPAA and Social Security Act laws that give authority to litigators to take action against NGS. I personally have standing because NGS has forced me to pay over $1,300 to one of their so-called network service vendors to transact standard claim and remittance files between doctors and Medicare. Shown here is my payment of $45 for 1 month, which I have made every month since July 2013. The federal statute that affects these transactions is known as the HIPAA Law of 1996. That law deals with many issues, but has a 10-page section titled Administrative Simplification that was inserted into the Social Security Act as Title 11, Part C, Sections 1171 through 1179. In addition to the HIPAA statute, a set of implementation regulations was created by the Department of Health and Human Services. These regulations are codified in Title 45 of the Code of Federal Regulations in Parts 160, 162, and 164. These laws generally apply to doctors known as providers and insurance companies known as plans, which are designated as covered entities. Section 1175 of the Social Security Act mandates that a plan must electronically transact claim and remittance advice files directly with providers. As shown here, if a person desires to conduct a transaction with a health plan, the health plan may not refuse. The health plan may satisfy the requirement by directly transmitting and receiving. Here is the corresponding regulation in 45 CFR 162.925. If an entity requests a health plan to conduct a transaction as a standard transaction, the health plan must do so. Section 164.506C3 of the regulations specify that no privacy agreements are needed for transacting these files, even though they contain protected health information. Simply put, these HIPAA laws say that if a provider has a data file in standard format, the plan must provide a place for him or her to send it, and no privacy agreements are needed. The purpose is to improve efficiency. The regulations say that if a plan does not want to do its side of the transaction, it can contract it out. A covered entity may use a business associate to conduct a transaction covered by this part. Finally, we will show 3 technical terms defined in the regulations that are important to this discussion. The regulations define a transaction as the transmission of information between 2 parties, includes healthcare claims. The regulations further define a standard transaction as a transaction that complies with an applicable standard and associated operating rules adopted under this part. The regulations define electronic media to include storage media and transmission media. Storage media may be a computer hard drive containing data. Transmission media is used to exchange information already on storage media. Internet is given as an example of transmission media. In closing, the so-called network service vendor entities created by Medicare and NGS are clearly their own contractors, and as such must be hired by them. Enforcing the doctors to hire them instead is a blatant and willful disregard for these laws. I suggest that the courts declare the following. A. All contracts between providers and their contractors and the so-called network service vendors be made null and void. B. All fees paid by providers and their contractors to the so-called network service vendors be reimbursed to the purchaser by NGS. That concludes this discussion. Please check out the action items shown here. Thank you and have a great day.